I'm trying to think of how to announce the next presentation without sounding too nerdy. But for those of you who follow the U.S. Supreme Court, you're probably aware of the Loper decision, which overturned Chevron deference. Many of you may be aware and have been thinking about how that impacts energy policy. But rather than think about it, we thought we would have one of the leading experts on this subject here today. So I want to introduce Varu Chilakamarri from K&L Gates, who is here to talk about all things Chevron. Thank you.
Thank you all. It's great to be here. So Chevron deference. I know we have a lot of lawyers and non-lawyers in the audience, and so we're going to try to keep it at a basic level. Today, we're going to try to cover what Chevron is. Some of you may not even know what Chevron was, so we will cover that. We're going to talk about the Loper-Bright decision that overturned Chevron deference, and then we'll dive into a little bit about what you might expect to see in energy policy. How is it going to actually affect you on the ground? Now, I'll get right to the punchline here. Chevron deference and Loper-Bright, these Supreme Court cases, they do not uniquely affect environmental law or energy policy. But I would say that energy policy is unique and has for a long time been very scrutinized by the courts. And so I think that's an important thing to think about when you hear about the landscape of the Supreme Court changing, that in some ways energy law was already at the forefront. It was already, because of its controversial nature, it was already an area where you are going to see a lot of interesting things happening, a lot of scrutiny by the Supreme Court. So that's kind of the punchline here. So Chevron deference. Chevron deference was came from a 1984 case from the Supreme Court. It was a judicial rule. It was a court-made rule by judges about how do you interpret federal laws. So it came out of a 1984 case, and the basic rule used to be that when you have a court case that turns on the interpretation, what does a federal statute actually mean, if the court looks at the statute, uses a dictionary, uses all the traditional, us lawyers call them tools of statutory construction, and the judges are just sort of stuck. They don't understand what a term in the statute means. Chevron, the Supreme Court in that case, basically said, well, if there's a federal agency that is the expert agency in this field, and that agency has come up with a rule about what the statute means, then the court must defer to the federal agency. That was what that's what Chevron deference meant. And a couple things to think about here that are important as we think about what's changed. When the court came up with this Chevron deference doctrine, it was kind of a sleeper case. People weren't that, it wasn't a huge front page USA Today like Loper-Bright was now. It was a kind of sleeper case. But what the court was saying in Chevron was that a federal statute, a law of Congress, could actually have multiple meanings. And both of those meanings, multiple interpretations, could be permissible. It was okay, and we don't know what the law means, and we're just going to let the federal agency decide what the law means. And that turns out to be pretty important, because what that allowed for in the last 40 years is for agencies to come in and change the law without Congress doing a thing. So that was very problematic, and it resulted in Congress stepping back, not doing anything, and changes in administration flip-flopping, which means as industry, people who are relying on a solid meaning of the law, there would be a lot of turmoil, and you've probably seen this a lot in your own practices. So that's what Chevron deference was, and I think it's helpful to think about it. If you're not familiar with it, just to get a concrete example, the best example is actually from the Chevron case from 1984, where the Supreme Court articulated this rule. The Chevron case was about the Clean Air Act and the EPA interpreting the Clean Air Act and what the term stationary source meant. So stationary source was the term in the Clean Air Act. Under the Clean Air Act at the time, if you were a power plant facility and you made a change to your facility to a stationary source, you'd have to implement new pollution control technologies. But the question is what is a stationary source? Is it one of these single smokestacks? Is it a single piece of equipment? Or is it the entire power plant? And like I said, you have back and forth. You had the Carter administration, which said that it's a single piece of equipment. If you change a single piece of equipment, you have to start implementing these new pollution control technologies. The Reagan administration came in with what they called the bubble rule. And they said, no, we're going to look at the entire power plant. And we're going to say that's a stationary source. If you could make changes within your power plant, but if the net emissions don't change, then you don't have to put on these pollution control technologies. So that's how we're going to define the term stationary source. So two different meanings. This went to the Supreme Court. An environmental group was actually challenging the rule. And the Supreme Court said, gosh, stationary source. They looked in the dictionary. They did all the things that the judges and lawyers do. They're like, we don't know what it means. And so they announced this rule where we're going to defer to the EPA because the EPA is the expert agency. So that's what Chevron was, and that's went along pretty well for 40 years. In the beginning, again, a sleeper case, but it really, really went hand in hand with the growth of the administrative state. You had a lot of new agencies popping up, a lot of new power for the agencies, and there's a debate about this. How important was Chevron? Are judges really out there confused about what laws mean? Do they really just defer blindly, or do they defer to the agency when they like what the agency is doing? It's an open question, but there have been studies that say that agencies, at least, when you have drafters who are in their agencies who are drafting these regs and doing Federal Register notices, that they knew about Chevron, and there was a study that said that 80% of those rule drafters at agencies were more likely to adopt an aggressive interpretation of a statute because they knew that Chevron was there at the back end. They knew they'd be backed up by that thumb on the scale. So, there's evidence that Chevron was actually pretty important in how agencies went about interpreting the rules that govern industry. But over the last couple of years, Chevron was on decline. It lost followers, or if you're in my younger generations, it really lost its riz, and it is stopped being cited by the Supreme Court. The Supreme Court stopped citing it for the last eight or so years, and it's because of this sort of flip-flop, right? People really don't like the idea that the agencies are making up laws that could be actually opposite when the new administrations come in. And the big change is that you got a conservative supermajority in the Supreme Court, where many of the justices who are now in the majority of the court had for a long time, they've been writing concurrences and dissents saying, we don't really like Chevron, it doesn't make sense, shouldn't judges be making the law? And finally, that is the sort of enough votes on the Supreme Court to have what we now have is for Loper-Bright. Now, Loper-Bright is one of the cases that the Supreme Court heard in the last few months where there were two cases that teed up this question of should the Supreme Court, after 40 years, overturn the Chevron doctrine? And the facts of Loper-Bright are less important, and I say that not because I have anything against fisheries, but actually the Supreme Court didn't even resolve the question that was at hand. Loper-Bright was another environmental case, and it had to do, in a snapshot, it had to do with the National Marine Fisheries Service, and they had a rule that said that fisheries have to pay for the cost of federal observers that the law requires them to have on their boats. They do, conservation management, and the question was who has to pay for these observers. And the National Marine Fisheries Service had a rule that said that the fishermen have to pay for the boat. So that was the question, is does the agency actually have the authority to make these fishermen pay? But the Supreme Court didn't resolve that question. The Supreme Court resolved the question of Chevron deference because the lower courts used the rule of Chevron deference to defer to the agencies. So what the court said was that, and you have a 6-3 majority, it was on ideological lines. The Supreme Court in late June said that Chevron was wrong. It doesn't matter that that was the law of the land for 40 years. It was wrong because judges and not agencies should decide what the law means. And what I said before, where you could have this idea that a law of Congress could have multiple meanings, they said that's just completely bogus. A law of Congress means one thing, and it doesn't matter if we can tell right away what it means or not. It means one thing, and it's the judge's job to figure out what that single best interpretation of the law is. Now, it doesn't mean that agencies have no power. They went back to this doctrine called Skidmore deference, which is basically, it's called respectful consideration. It's like when you say, with all due respect, and we all know what that means, right? It doesn't mean much, but that's what they said. They said, if an agency has an interpretation of a law, then we will look at it, and if it's reasonable, maybe they'll persuade us. But at the end of the day, judges will not be controlled by what the agencies say. They'll just look at it just like they will look at arguments that the regulated industry is making. So, big change. It is, I would say, Chevron was cited in over 18,000 cases. It was significant for administrative law for the last 40 years. So this is a sweeping change in how agencies are actually going to go about making rules that regulate industry. But there are some things that didn't change. And if you're in this field, or if you've been reading the press on this, some people are saying that the world is over, agencies have no authority to do anything. And I think it is important to kind of just set the guardrails of where we really are, and then how it affects energy law. So first of all, Chevron deference, and now the overturning of Chevron deference and Loper-Bright, they are about federal law. They don't affect state law, at least not directly. Chevron was about federal judges and how they interpret federal statutes and how much sort of weight, how much of a thumb on the scale agencies should get. They don't affect state law at all, but interestingly, before Loper, about half the states had their own version, sort of mini Chevron. They had their own version of Chevron. Half the states gave deference. The state of New Jersey, a few years ago, the Supreme Court decided that in New Jersey, you should have something similar to Chevron deference. And so state judges here do give some deference to state agencies when they are trying to figure out a vague meaning of a state law. So I think we are going to see this having a trickle-down effect on states and how states are interpreting their own laws. We're already seeing, particularly where the states had relied on Chevron, where they were just kind of piggybacking or copying what the federal government was doing, you might see the states kind of back out of that. But it is a separate issue. In terms of federal law, okay, so I think you are going to see a lot of short-term uncertainty. And that's because, stepping back, federal agencies, they're still going to regulate, they're still going to issue rules, they're still going to enforce, and it's going to be very important not to ignore them, right? They are still setting the default, the line of what is expected of industry. But there's no longer this thumb on the scale, so they're less likely to win every battle than they were before, because now if they're interpreting a statute in a kind of iffy manner, if you will, now your interpretation might be just as good, and you have a better chance of eventually winning on that interpretation. So because of that, a lot of uncertainty in the beginning and a race to the courthouse. More litigation. And I think why you're going to see more litigation is because the judges are going to have the final say. And they always had the final say, of course, but now, remember when we talked about this flip-flopping, now the judges, the Supreme Court has said that there is one single best meaning of every statute. So if there's an ambiguous term in a statute, the Clean Air Act, Federal Power Act, there is going to be a race to kind of figure out what does that mean. And once you've exhausted your appeals and gone to the highest court that you can possibly go to, that's going to be the answer about what a statute means until Congress changes it. That means that if you challenge a rule that the Biden administration has put out and you eventually get that litigated, it doesn't and they win or they lose, it then doesn't matter if another administration comes in. So the proponents who wanted to overturn Chevron, their idea was that, okay, you're going to have some short-term uncertainty, but in the long term, what they hoped for was a solidification of what the law means and more certainty when you take the longer-term horizon. Now, some things didn't change, and it is important, again, there's been a lot of discussion of the world is over, administrative state has completely collapsed. A lot of things didn't change, at least not yet. And one of those things is that agencies still get what we call arbitrary and capricious deferential review. So I'll give you an example. Things like when Congress gives the agency the authority to set standards, like under the Clean Air Act, Congress gave the EPA the authority to set NAAQS, the National Ambient Air Quality Standards. And they allow the EPA to set a number, what is too much pollution in a particular area. So when the Congress is clear, it tells the agency what to do, and it says act reasonably within this range, then the Supreme Court in Loper Bright said that they can continue doing that. EPA can continue issuing rules and making, I would say, fact-finding policy judgments. Those are still going to be the same and reviewed under the same deferential kind of standard of review. It's when you get to a legal question that you're going to get this new Loper Bright standard where agencies no longer have any special weight, and it's the judges that will make an independent determination. It's easier said than done. When you're a lawyer, you're going to see that a lot of people are going to be saying, well, actually, every question is really a statutory interpretation question. They're going to get those kind of arguments because it's better for the challengers. Now, how does this affect energy policy? It's interesting. As I said very, very beginning, I think energy policy and environmental law was one of those areas where it was already under a lot of judicial scrutiny. It's no surprise that you had Chevron, Loper Bright, West Virginia versus EPA. All of these really significant cases are actually environmental cases. Now, the administrative principles apply across the board. They apply to healthcare. They apply to labor law. But there's something about energy law that kind of gets people very up in arms. It can be controversial. And I think what you're going to see is that Loper Bright happened at a time when you have the Biden administration trying to use a whole of government approach to tackle climate change and doing things like, trying to decrease carbon emissions from power plants, increase electric vehicles, using financial disclosure laws to try to improve transparency on greenhouse gases. All of those things are, some would argue, trying to fit square pegs in round holes. And when you have an administration that is trying to move forward in those areas, but the laws aren't really designed for that or aren't clearly, that's not what Congress was thinking about, that's when the rubber meets the road. That's when you get these cases where challengers have sometimes very good arguments that the agencies are acting beyond what Congress intended. So I think it's hard to say exactly how much Chevron affected energy policy in the first place, but before Loper Bright, you can't read this at all, so I'll just tell you what it says, but there was an interesting study by the Michigan Law Review that looked at cases where the courts were citing Chevron, and they were trying to figure out, how often did the agency actually win when, someone argued for Chevron deference. And interestingly, the Chevron framework, before Loper Bright overturned it, Chevron was applied in 96% of all energy cases that were brought up to the federal circuit court level, right before this, under the Supreme Court. That's pretty high. If you looked at the top of this list has, for example, telecommunications and Indian law issues. Those issues, Chevron was applied maybe 80% of the time. But in those cases, the agency actually won 80% of the time. For energy policy, Chevron was applied 96% of the time. The agencies only won 60% of the time. So somewhere along the line, the court applied the Chevron framework and decided either at step 1 of Chevron, it's not going to defer to the agencies, or at step 2, the agencies had an unreasonable interpretation. So even before you got to Loper Bright, Chevron Chevron was used, but the agencies were not winning as much as they win in other areas. And I think that speaks to the challenges of energy law cases. These are really complicated, hard questions that people have, that judges have a hard time with, and that agencies have a hard time with at the federal level. So when we think about what we're going to expect, I think rather than speaking kind of broad sweeping propositions, because again, energy policy is very nuanced, I would say I would be on the lookout, as part of the industry, you'd be on the lookout for a couple of places and buckets, if you will, of the types of arguments that if you are trying to challenge a federal law or you don't like the way the agency is acting, I would think about these sort of three buckets that I'll talk about. Or if you like a federal law, then you should be thinking about how you would defend that policy, whether you're in court or in the public sphere. The first is the very kind of most obvious thing is where there's a real ambiguity in a statutory term, where something is affecting your area, and there's a question about what does a statutory term mean. We're seeing this already. So, for example, the Clean Air Act, and you're going to hear from my colleague running a panel soon about electric vehicles. There's a big question now about California trying to impose an electric vehicle across, mandates across the country, essentially. And there's a question about the Clean Air Act and whether or not the EPA properly is granting a waiver to California for these electric vehicle mandates. And those questions turn on whether or not California, and because normally one single state isn't allowed to have a higher emissions rates for its vehicles, but there is in the statute, the statute that Congress passed, the Clean Air Act, it allows California and only California to do this, right? And when California can do it is when California decides that there is an extraordinary condition. So there's a term in the statute, and there's a whole bunch of lawsuits in the DC Circuit. One is pending before the Supreme Court, and it's about whether or not climate change is actually an extraordinary condition. Was Congress, when it gave California this special power, was Congress thinking about something like climate change? Or was it thinking about localized problems like smog? People who don't like the California waiver are arguing, actually, they were thinking about smog. They weren't trying to give California the authority to regulate the entire nation or the globe, for that matter, right? So that question of what does an extraordinary condition, that term in the statute, that is going to be debated, and Chevron is gone. So the EPA is not going to be able to say, you should defer to us, you should defer to the EPA. They're going to have to argue about what Congress really meant. It's going to also, you no longer have that thumb on the scale for the agency, but it's going to invoke larger questions, the major questions doctrine, which is kind of a thumb on the scale in the other direction. That's a rule that came out of the West Virginia case, the West Virginia versus EPA, the Clean Power Plan, where the court said, not only do you not defer to the federal agencies, but if what the agency is doing is going to cause a significant economic or political issue, then you need even more clarity from Congress. So that's the kind of issue you're going to see coming up when it comes to statutory analysis and terms. This issue is also coming up on the FERC side, on the power side. We had a discussion about nuclear power, and there's a question about solar plants. Under the Public Utilities Regulatory Policy Act, there's a question about what does it mean to be a qualifying facility under that act. If you're a qualifying facility, you create 80 megawatts or less beneficial treatment. There was a case that went up to the Supreme Court, and because of Loper-Bright, the court sent that case back and said, this was the Broadview Solar case, that FERC's interpretation of what a qualifying facility is no longer owed deference, and instead the DC Circuit has to go back and decide on its own what does that mean. In that case, it had to do with whether or not you measure the qualifying facility by how much power it can actually inject into the grid versus how much power it actually can create and store on its own. We're seeing so that's the first bucket. The second bucket of things I think to keep your eye out would be about agencies exceeding their authority. Now, this isn't about specific terms in the statute, but an overarching idea about what did Congress actually mean to allow agencies to do. We're seeing this in the, earlier was mentioned, FERC Order 1920, and about whether or not FERC has that kind of authority to actually make transmission planning that far out? Does it have the authority to require all of these policies and procedures going out 20 years from regional transmission planning facilities? And when FERC came out with FERC Order 1920, Loper Bright had just come down, and there was actually a public dispute between the commissioners about whether FERC even has the authority under the Federal Power Act to go this far with this order. The leading commissioner said, Loper Bright doesn't affect us, whereas the dissent wrote a big, long explanation of how now under Loper Bright, the agency doesn't actually have that kind of authority under the Federal Power Plan. So we're going to be seeing questions of whether or not the agencies that are acting in the energy space even have that authority to exercise and to kind of create these novel new standing rules. And then finally, the last, I think, area to look at would be when Congress does delegate to the agencies, are they doing it specifically enough? In Loper Bright, the court said that agencies, they can get authority to interpret the law if Congress is clear. And the example of the NACs under the Clean Air Act, I think, is a good one, where Congress says, we want you to issue a rule, to regulate air emissions on a particular pollutant basis. The SEC climate disclosure rule, I think, is one on the other end of the spectrum. Here you have the SEC arguing that Congress did give it the authority to require public filers to have to explain their greenhouse gas emissions, their climate risk in public filings, and the SEC is hanging its hat on what Congress gave to it. Congress gave it the power to require public filings that are, as the SEC chair deems it necessary and appropriate to protect investors. That's a pretty big mandate, but the SEC is saying that necessary and appropriate to protect investors actually applies to climate change. And so the question there is, did Congress, yes, you can point to a delegation, but was it really specific enough to give the SEC the authority to make public companies give that kind of information? So you're going to be seeing Loper come up, but I would say it's in a more sort of nuanced way. It's not that every case is going to be lost for the agency, but you're going to see it come up in specific events. But I do think that energy policy is unique, and it's hard, and it's important to think about it from a kind of long-term public policy life cycle. It's not just, we've been talking a lot about court cases, but it's not just court cases. When you go to Congress, when you're thinking about federal statutes, it's going to be very important to get with your policy folks, make sure that you're getting the language right, because there's even more of a premium now on making sure that the statutes say what you want. And even if you don't have that political capital to get Congress to pass a law, because that's very difficult, it's important to make sure that you don't have bills being put in, that Congress is rejecting bills that are unfavorable to you, because now the courts are going to be looking at really what's happening in Congress, what's happening in the floor, what's happening with the legislative debates. So getting in there's more of a premium, I think. And then, of course, it's always going to be important to have good relationships with the agencies, because they're still, by and large, and for most routine matters, they're still going to have a lot of authority and control. Loper Bright doesn't change that. But again, more litigation, more opportunities to challenge rules that you don't like. So I'll end there. Any questions?
Yeah, sorry, this is just more of a clarification question. So one thing I'm curious about is that in the energy space, we have a lot of new technology. And I think even Scalia said, right, that you can, reinterpret the statute, right, when there's new technology, that will, come into play in your interpretation. And so I imagine that agencies will have to do that from time to time to accommodate the new technologies. And where do you think that will play in with, overturning Chevron deference? Because I know you mentioned, kind of not flip-flopping back and forth in terms of interpretations, but to me this seems a little bit different because, you
Yeah, that's a great question. I think there are a lot of environmental statutes that have, reference to the best available control technology, and I think the courts are going to look to Congress using those kinds of phrases but which, that indicates that Congress is really handing it over to the agency to evolve. But I think if Congress doesn't use those kinds of terms, there's not going to be anything for the court to say that the agency has the authority to push industry, to evolve like that. Thank you.